Welcome to our YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal. And this particular video focuses on construction employees who've been fired or terminated from their job. And all too often, they simply look too quickly into what their rights are or what the limitations on their rights are upon being fired or terminated. Or they get secondhand information as to what the general practice is. And that general practice, that information, suggests that the only thing that exists is a regulation that exempts construction employees from receiving termination pay. And based on that regulation saying you're exempt from termination pay, you're exempt from termination notice, far too many construction employees think nothing more about whether or not they are entitled to something from a legal standpoint. And that's a serious mistake to make. Because as we'll see by looking at the case of Cunningham versus Hillview Homes Ltd, an Alberta Court of Queen's Bench case, we'll see that there is something far more for construction employees than the minimums that exist. Because as we'll find out, minimums are there to protect employees, but they are not the end-all and be-all, because the law provides for additional remedies and relief to employees that go beyond the minimums that are found in the statute, in this particular case, the Alberta Employment Standards Code. And beyond that, what we find is if we look, there is more protections that are found in the legislation to protect those employees, including employees in the construction field, and offering them relief through the judicial process. And that is actually found in the code and is actually supported by court precedent, by analysis of learned judges who analyze the situation. So what we need to do is we need to look at specifically what Justice David Gates said in rendering his decision in favor of the construction employee in the Court of Queen's Bench, Terrance Cunningham versus Hillview Homes Ltd. And we start off by looking at the underlying law. And a couple key things are: one, in the preamble stated that recognizing that legislation is an appropriate means of establishing minimum standards for terms and conditions of employment. And another key point is Section 3 of the Code, which says nothing in this act affects any civil remedy of any employer or an employee. Critical information to remember. Now, what did the case go on to decide? Well, two key things for a construction employee in most circumstances. One, does the combined effect of the Employment Standards Code, being sections 138.3 and 6 and regulation 5.1a, extinguish an employee's right to pursue a civil remedy under section 3 of the code? And secondly, what period of notice was the construction employee entitled to receive pursuant to the common law remedy for wrongful dismissal? Those were the two important questions that were decided upon and rendered in favor of the construction employee in this case. And without trying to provide any overstatement of interpretation, what we'll simply do is we'll simply cite off to you the key findings of the court, the key decisions of Justice Gates that he made, and allow you to elucidate from them and to see that this is something that is of consequence to yourself as a construction employee that you should consider and should talk to with legal counsel about. Because where the facts and circumstances allow, there may very well be a case for yourself as a construction employee who's been recently fired or terminated from their job, and has been offered nothing in the way of termination and severance pay because your employer, falling back to standard practices of employers, decides at the outset at least to simply offer you nothing and hope that you move on. They might even offer you something, but it's far below what is required. And we'll even see in the Cunningham case at the end, what was provided for by the court is quite substantial when you really think about it. But let's move on to some of the findings from the court, both in this case and other cases that were material and were raised. So one of the key cases that was raised is a Smith versus Hostess Frito-Lay case from 1994. And there it focused on drawing upon decision of the Supreme Court of Canada in Machinger versus HOJ Industries Limited, where it said the objective of the act, being employment standards legislation, is to protect the interests of employees by requiring employers to comply with certain minimum standards, including minimum periods of notice of termination. The general intention of this legislation is the protection of employees, and to that end, it institutes reasonable, fair, and uniform minimum standards. The harm which the Act seeks to remedy is that individual employees, and in particular non-unionized employees, are often in an unequal bargaining position in relation to their employers. Then it goes on to look at the Supreme Court case of Rizzo and Rizzo Shoes Limited. And there it talks about the underlying objectives of employment standards legislation, saying that it was in this context that the majority of Machinger described the object of employment standards legislation as being the protection of the interests of employees by requiring employers to comply with certain minimum standards, including minimum periods of notice of termination. Accordingly, the majority concluded that interpretation of the employment standards legislation, which encourages employers to comply with minimum requirements of that legislation, and so extends its protections to as many employees as possible, is to be favored over one that does not. So, in summation, the judge in Cunningham said, on the authorities as referred to above, it seems clear that the fundamental purpose of employment standards legislation is to protect the interests of employees. The legislation is to be interpreted in a broad and generous manner. Further, any ambiguities in the language used in the code should be resolved in favor of the employee. The exceptions set on the code and the regulations are to be narrowly construed. And by narrowly construed, that means if there are exemptions to it, if there are means to get around it, such as by the common law, then we are to look at those areas. And this is particularly important for construction employees. So now we move on to some of those aspects, where we go to say, once again, the statute have held to be set minimum notice periods and do not in any way affect the employee's rights to have the issue of reasonableness of the notice determined by common law. So common law is a critical aspect here in that it allows a basis that goes beyond what is in the statute, and it is fundamentally protected by the statute, and that is found in Section 3 of the Alberta Employment Standards Code. And in so doing, it says, nothing in the code affects any civil remedy that an employee may have against his or her employer. And here we look at Driscoll versus Conseco Resources Limited, where the judge held the Employment Standards Code set the minimum standard only. Current Section 3 preserves any right that was greater. It is not restricted to that minimum. So the minimums, what we're talking about, are in the regulations. And in the regulations it said there's an exemption here, but those are just minimums. You can go beyond And that is what you have to go to the court to find. That's what you have to go to legal counsel for. And in so saying, the court said, I reject the defendant's contention that the reach of Section 5.1a of the regulations as authorized by Section 138 of the Code overrides an employee's right to pursue a civil remedy as set out in Section 3.1 of the Employment Standards Code. And the judge went on to say, while I accept the defendant's arguments that effect of Section 5.1a of the regulations is to actually eliminate the statutory right of a minimum period of notice of termination for an employee covered by that section, I do not agree that Section 5.1a also extinguishes an employee's right to pursue a civil remedy pursuant to Section 3 of the Code. The preservation of the right to pursue a civil remedy now found in Section 3 of the Code has been in place since the introduction of the Alberta Employment Standards Code in 1980. Very important that there is that preservation of that civil remedy right that is over and above the regulations wording. And it goes on to say, nevertheless, he was entitled to a common law remedy for wrongful dismissal in accordance with Section 3 of the Code. Very important. So that means, as a construction employee, there is still relief to be pursued. Because you've been fired or terminated, it is not the end. You can pursue relief. And it's very particular. It's interesting when we look at Cunningham, what kind of relief was afforded to the construction employee. It was even said. The authorities make it clear that the period of notice an employee is entitled to receive pursuant to employment standards legislation, including the Alberta Employment Standards Code, reflects his or her minimum entitlement. And given the provision of Section 3 of the Code, an employee's right to pursue a civil remedy for wrongful dismissal is preserved. Then the judge went on to say, notice periods in excess of 1 month for every year of service are typically reserved for employees terminated from executive level type positions. Non-executives, meanwhile, will be entitled to between 2 weeks and 1 month notice for every year of employment. As such, in this particular instance, the construction employee who had worked for 11 years and 7 months was entitled to a notice period of 11.58 months. So almost a full year's worth of wages he was entitled to upon his termination. So as you can see, simply looking too quickly at something is not in your best interest. Take the time. Just because you've been fired or terminated from your construction job and you read something quickly, there could very well be very much more available to yourself. And the law is there. This is case precedent. It's not my own making up stories. This is the law. Yes, it's the law in Alberta, but it is the law. And this is what the court ruled. And it took upon itself to look at the regulations and the Employment Standards Code, to draw upon them, extrapolate from them, and find the determination that was consistent with the statute, particular Section 3, and allowed for the pursuit of the civil remedy. And the civil remedy was quite substantial, being nearly a full year's wages being due to that construction employee. And that is what you have to recognize, that there is more than simply looking at a couple words. Construction employees are oftentimes entitled to severance pay that arises following their termination or following being fired. But unless you pursue it, unless you look into it, you won't necessarily be able to attain it. So that's why it's important that you take the opportunity to speak with knowledgeable legal counsel when the situation arises and see what can be done, what strategies are available to yourself to pursue what you are legally entitled to. Hopefully we provide you some insight and information that's useful to yourself. and can allow you to deal and advance the situation you find yourself in when you've been terminated or fired from your construction job. Thank you.